Good afternoon. I, Dhruv, Assistant Professor, Faculty of Law, currently associated with Mary Professional and Law Institute. Today, we will discuss the various provisions of Indian Partnership Act 1932. Before proceeding with the provisions of Indian Partnership Act 1932, we need to discuss some basic terms as well as the background and the history of the Indian Partnership Act 1932. Prior to this act, these sections were under Indian Contract Act 1872, but later on there was an amendment and there is a specific another act has been made by the statute that is called the Indian Partnership Act 1932. Indian Partnership Act 9 would come into existence on 1st October 1932. Only the one section, that is section 69, which talks about the effect of non-registration of the partnership firm will come into existence on 1st October 1933, means the 1 year later after all the sections. There are total 74 sections in Indian Partnership Act. Now, before proceedings with the important provisions or the important sections of the Indian Contract Act, we need to discuss some basic terms of the Indian Partnership Act. These are the partners, firm, and partnership firm. Whenever we are talking about the partners are the persons who have entered into the partnership firm by one another is called individually partners, means those are partners of the firm. Firm, persons who have entered into the partnership firm collectively called as a firm. And the third one is a partnership firm. So the section 4 of this particular act itself defines the meaning of the partnership firm. Partnership is a relationship between two or more persons who have agreed to share profit between them, who have agreed to share profit of the business carried on by all, or any of them acting for all. So a particular section itself discuss the various essentials of the Indian Partnership Act 1932. The first one is there must be an agreement who have agreed. So it means कि there must be an agreement between the partners. The second one is we need to require at least two or more persons. So this is the second essential. And the third essential is sharing of profit. There must be a sharing of profit between the partners. And the fourth one is the business must be carried on by all or any of them acting for all. So this is the fourth. So now let's elaborate one by one all the essential conditions of the Indian Partnership Act 1932. The first one essential of the Indian Partnership Act is there must be an agreement. Means for making a partnership valid, for constituting a partnership, there must be an agreement between the partners. That agreement may be oral, written, express, or implied, but that must be consented between the partners and they have been agreed to enter into the agreement for the partnership firm. The second one is there must be a two or more persons. So the minimum requirement for entering into the partnership firm, we need to have at least two partners. So there was an Companies Act 1956. In that act, there are the two kind of partnership, those who are rendering the services of banking services and the non-banking services. So those partnership firm which will cover under the banking services, the maximum limit was 10, and those who are working under the non-banking services were 20 in total. But later on, there was an amendment, the Companies Act 2013. They have increased the capacity or the limit of the partnership, and now they have exceeded up to 50 in total. The third one is who have agreed to conduct a business. Means there must be carry on of a business. Means business must be lawful. Who have agreed to conduct a business means there must be an business carried by the all partners or any of them acting for all. The business is itself defined under this act under section 2 subsection B. Business includes any trade, occupation, or profession. So partners must carry business between themselves, but that business must be lawful, that must not be unlawful. The fourth one is with sharing of profit. So this is the fourth essential of Indian Partnership Act 1932 कि there must be an sharing of profit between the partners. And the fifth one is business must be carried on by all or any of them acting for all, which is also known as a mutual agency. So let's discuss two important case laws as well. There was a case, Grace versus Smith. In this case, the court held that sharing of profit between the partner is a conclusive test of partnership firm. But later on in the versus Hickman, in particular case, it was held that it is not a conclusive test of partnership, but it is only essential condition sharing of profit between the partners. But in the particular case also they have let down the concept of mutual agency and have been told that mutual agency is a conclusive test of partnership firm. So these were the various essentials of the Indian Partnership Act 1932. In the later on classes, we will discuss the further more provisions of Indian Partnership Act 1932. Thank you.